So Judge put out his decision today on those surveys that defense was doing in preparation for their change of venue hearing. And basically he sidestepped whether it was a violation of the non-dissemination order, even though you could tell during the hearings that he felt that the two questions that were not factual were a violation. In his decision, it was basically that once the toothpaste is out of the tube, you can't put it back in. So there's no point in halting the surveys or rewording them. So it's basically what that is. Those two questions got put out there. Can't do anything about them now. They're in the public purview, so complete the surveys. So the stay on the surveys has been lifted, and I'll show you some highlighted portions of his decision. So this is just the first page of the order, and it says order allowing defense surveys to continue. And we're going to go to the next page. So this page is important because he points out the April 4th, 2024 hearing was open to the public because neither party requested that the hearing be sealed. At that time, the court heard arguments from both parties regarding a survey the defense had conducted in Latah County and wished to conduct in 2 additional counties. The state took issue with 9 of the questions of the survey, which were read into record in open court, and asked that those specific survey questions to potential jurors violated the court's revised amended non-dissemination order. So, important part. Neither side asked for the hearing to be sealed. So we go to page 3. Same thing. On April 10th, 2024, the parties again reconvened in open court. Again, neither party requested that the hearing be sealed. Now, why was that important that he pointed out that at both hearings, neither party had the hearings sealed? They didn't ask for closed hearings. It's because it put those questions out into the public purview instead of it just being to those 400 survey participants. So that's what enabled Judge to reach his conclusion that it's now out in the public so the surveys can continue. I think that was very strategic, of course, by Anne, because she wanted those out there. But I think it was also strategic by Bill Thompson, because here's the thing. The media is who ran with the stalking angle. And the media is also who ran with the social media connection angle. And neither have turned out to be true. But because of the gag order, neither law enforcement nor the prosecution could come out and say, hey, knock it off. This isn't fact. This isn't in the probable cause affidavit. We never said he was stalking them. We never said he contacted them on social media. That would be a violation of the non-dissemination order for law enforcement or the prosecution to talk to the media about that. So Bill's way around it was having it brought out in a court hearing. And now those rumors were put to rest officially by him. So I think it was strategic on both sides. And yeah, non-dissemination order was likely violated, but both sides got around it. Now here's where the judge addresses about the public record. So he says, as to the remaining 2 questions prior to the hearings, there was not information contained in the public record about those items. However, these questions have now been read into the public record and discussed at length during the hearings. And you can pause this and read the rest of this. But that makes up his basis for saying, hey, it's out there now. Can't do anything about it. And then this last page is really interesting too, because he also brings up that the non-dissemination order was meant to stop harmful information from getting out there, things that could be prejudicial, the publicity, etc., especially for the defense, the client, for Brian Koberger. But basically he's saying that if Ann Taylor feels that putting that information out there is not prejudicial to his client or her client, then who is he to tell her she can't? Basically, he's saying this court does not, at this juncture, have sufficient information or evidence to second guess the strategic decision by trial counsel. So he's saying, Anne, if you feel comfortable with this, then go ahead. So, in summary, it likely violated the non-dissemination order to do the surveys, but because both sides didn't have a closed hearing, the questions got out there to everyone. And once that toothpaste is out of the tube, you can't put it back. So the judge saw no point in stopping those surveys. So the stay is lifted. That's where we are now. Next up will be the hearing about the change of venue, which will happen in June. And then also later this week, I'm going to do a YouTube about the defense expert on the cellular technology, the information for Brian Koberger's phone and his alibi, because Cy Ray is being talked about like he's some sort of bombshell for this case. And really, he's not. There's a lot to dig into about him and him testifying for the defense. So I will put a YouTube about that later this week.